The case is now being live streamed. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Today is September 30th, 2020. My name is Amy Blake. Along with me today, we have Justice Greg Massing and Justice Eric Neyman. We are your panel for the 4 cases that we'll be hearing this morning. Because there are only 4 cases, we will be going straight through and we will not be taking a break. Although we're doing this virtually, the normal rules apply, and that is that each side has 15 minutes. There is no rebuttal. I can assure everyone that we have read your briefs and all of the case materials, so please use your time wisely, but we are up to speed on the facts, as they say. So the first case we're going to hear this morning is Commonwealth versus, and I apologize if I mispronounced this, Josue Compres, 19P0690. Attorney Hahn, when you're ready.
Good morning, Your Honors. Thank you very much. And the client's name is pronounced Josue Compres.
I apologize.
Josue is a little bit uncommon. So thank you very much, Your Honors. So I appreciate that the court has possession of the videotape, and I move for its admission. And I understand the video at this point has been admitted. I appreciate my sister, the Commonwealth, in agreeing to its admission. So I know the court has viewed it, but just to reorient us. So it's a surveillance video. So we as the viewer are sort of looking down at what happened. And it's an interaction between Mr. Compres and 4 police officers in a vestibule. And this immediately follows some interactions between Mr. Compres and Lieutenant Basalt. I'll talk about his testimony in a moment. But just in terms of the video, Mr. Compres is on his way out. We see him sort of come into the frame. First, we see his friend sort of ushering come out.
So the video is after the interaction and him learning that he's not going to be able to get his brother, and you say he's on his way out of the building at that point.
Indeed, Your Honor. Yes. Okay. So that's exactly right. So we have this interaction inside between my client and Lieutenant Basalt, and I'll jump there for a second, in light of Your Honor's question. So based on the testimony essentially taken as true, there's this interaction between the 2 of them. As you say, Mr. Compres is there to pick up his juvenile cousin. Lieutenant Basalt says, no, that's not going to happen. My client becomes sort of belligerent and bellicose. He's upset and he appears to have had some alcohol. At some point, Lieutenant Basalt has sort of lost his patience and comes out from behind the glass and says, you're going to have to leave. And there's a little bit of a dispute as to what happens then, which I'll come back to, but just setting the stage, that's absolutely right in terms of the time sequence, Your Honor. So the video.
And also Lieutenant Basalt, the court testifies, I told him he's under arrest.
Exactly. And so that's, I think, very much in doubt. So first of all,
in doubt about that. I mean, light most favorable to the Commonwealth. He testifies, I told him he's under arrest.
Well, he sort of backs away from when he told my client that he was under arrest. The testimony at first is extremely unequivocal. I came out from behind the glass and I told your client he was under arrest. So that's the clear testimony. Then on cross, gradually the testimony evolves, and I'm not claiming, that there was any, attempt to mislead, but the testimony changes. And basically, eventually, sort of Lieutenant Basalt says, yeah, actually, it happened sort of closer to the vestibule. So his testimony becomes more consistent, but the video is not at all consistent with him ever being told he was under arrest for the following reasons. So again, to set the stage of the video, he's on his way out, Mr. Compres. He has a 4-man escort, so 4 police officers. They do have their arms on him, their hands on his shoulders. He's walking, though, of his own accord, and he gets to the vestibule, this group, and things sort of go off the rails. And the way Officer Foley testifies to this, I think, is a pretty accurate characterization. that Mr. Compres, quote, started to spin and pull away from me. Page 33 of the transcript. I think that's pretty fair. But when you see the video, it's just this sort of awkward kind of physical breakdown of things that can happen when you've got four people sort of pressed together. There's this sort of awkward twisting of Mr. Compres' arm. I'm not going to assert that there was any intent to twist his arm. I don't think there was any intent from anyone. It just sort of goes off the rails, and then very quickly these officers swarm on him. Frankly, you look at this video, as I have many times, it doesn't really get more pleasant as you watch it. I think it is troubling. Mr. Compres is essentially pressed up against a wall very hard with one of the officers' hands. And then once he's handcuffed, which is very quickly, he's dragged backwards through the lobby, and they absolutely could have steadied him, and his head bangs on the concrete.
I agree. That's the pressing against I'm looking at it right now, pressing against the edge there, the dragging him back. That's all very troubling and disturbing. However, isn't that all after the crime?
I'm just not clear sort of what the crime is, Your Honor. And
Well,
I don't
it's trespassing, resisting arrest, and vandalism. The latest of those is the resisting arrest, and at that point they're effecting the arrest.
So if I could take those in turn, because I do think it's important to sort of tease them apart. The vandalism charge is both the most significant and I think the weakest. It's clear from the transcript, it's undisputed. Mr. Compres is 19 years old. He doesn't inherently get a pass for being basically a kid, but he is an extremely young man, and he ends up with a felony conviction out of this based on alleged damage to the officer's uniform. That's the whole predicate for this. And it's Officer Cozzolino's uniform. But Officer Cozzolino doesn't testify. All we get is this stray line essentially from Lieutenant Basalt. Oh, I looked at the uniform and there was some damage to it. Extremely vague testimony. And I think this video is essentially exculpatory on the vandalism charge. We don't see anything whatsoever about a jacket being ripped. I mean, this is just a rapid altercation, a disturbing physical altercation.
But even if the video doesn't show it, right? This is a sufficiency question, and we have to view the evidence in light most favorable. And there was testimony about this ripped pocket, and I hear you that it's not shown on the video, but is that the end of our inquiry?
Well, I think the review has to be more than formalistic. And I think it's almost one where you could sort of take the testimony almost as true as the reviewing court. It's just so vague. I mean, there has to be a mind state to prove vandalism. And it's a fairly low mind state. It's sort of wanton conduct. But we see, for example, the McDowell case from 2004 from this court. Someone gets into a car when they're drunk. They end up hitting another car. That's wanton. To get in a car, you make a call. You make a decision to get in a car, and you're drunk and you harm someone else's car. That's a wanton state. I don't see what his mind state could be.
So you're saying that it was sort of ancillary, that there was this kerfuffle in the lobby, and as part of it, somebody's pocket got ripped, but there was no intent to do so?
Not even at the most basic level of sort of constructive wanton intent. No, I mean, I think we have to tease these things apart. Again, he's on his way out. That's really the problem I have with this. He's on his way out of the station, and the testimony is pretty palpable from the cross-examination. How is it that he's trespassing when he's on his way out? I mean, the officer's testimony, Lieutenant Basalt's testimony that, I placed him under arrest immediately. It's just not accurate. It's just not accurate. He's on his way out of this police station. He's walking of his own accord. It's unfortunate that things broke down. I don't think it's anyone's fault. I mean, we have the video. It's this awkward physical twisting. And I just don't think you have the mind state. This guy was manhandled by these police. And just because someone's, jacket might have been ripped, which we don't see We just have to imagine that that's not a mind state. I mean, that's not a felony conviction to, when you're being manhandled by 4 police, you're being dragged, you're being slammed against a wall. You're basically.
How do those facts go to, I understand your argument on vandalism. How do those facts go to the sufficiency of trespassing and resisting?
Yeah, when you're leaving a place, you're not trespassing. You're trying, and he's 2 or 3 feet away from this being over. Again, I just don't think it's his fault that this happens. He's walking out. It's clear he was acting like a knucklehead within the station. I don't know that being a knucklehead equates to these charges. But in any event, I don't know, how can you trespass when you're leaving? Same with resisting arrest. We don't have.
Mr. Hahn, isn't there a view of the evidence, if you take the testimony, that he doesn't start to leave, the leaving doesn't occur until after he's been told you're under arrest, and then they go to effect the arrest and they grab him, and that's when he leaves. But that could also be seen as resisting the arrest at that point.
I don't think we can credibly sort of accept on any review at all that he was placed under arrest within the station, before reaching the vestibule. And the testimony of Lieutenant Basalt kind of shifts on that. And he basically says, oh, I effected the arrest closer to the vestibule, closer to. I don't understand. I mean, he's clearly walking out. These officers, in some ways, I would give them credit for just kind of saying, let's get this knucklehead out of here. Let's walk him out. But let's assume they arrested him within the station, that, consistent with Lieutenant Basalt's initial testimony, Lieutenant Basalt comes out and says, sorry, guy, you're under arrest. There's no earthly reason why you would walk him out of the police station. I mean, you'd bring him back down. When they arrest him, they drag him in. We know from the testimony that the cells are in the basement. So I don't think it strains any credibility, regardless of how lenient the review, that you arrest someone and let's get out of here. You're under arrest, so let's.
But to put a finer point on Judge Massing's question, you don't dispute, do you, that he was asked to leave the building several times and said he wouldn't leave? Eventually, we see him on his way out. But each and every time that he was asked to leave and didn't, why is that insufficient for trespassing?
Well, again, I don't see if you actually are on your way out. So I guess
I'm drawing the line before that. The several times that he was told, you got to leave. And he said, I'm not going anywhere. My words, I'm paraphrasing. Isn't that the trespass?
Yeah, and I understand Your Honor's point. And ultimately, I think the weakest count here is the vandalism count. That's the felony count. I mean, I think the whole nucleus is very vulnerable, but I think the vandalism count is the one that I'm really most concerned about. I do, for me, just if you're asked to leave, at what point does it become a legal trespass? If you have this fact added in that you're leaving. So
can I ask you one more question about the vandalism?
Yes.
So I mean, assume this is not the court's decision, but assume that we were to say that there was a resisting arrest, which would the state of mind of the defendant actively resisting the officers. Does the act of resistance, isn't he responsible then for what happens during that?
So I guess you're stating, if one is resisting arrest, does that not put you into sort of a wanton mind state that would also be a predicate for vandalism? I think that's sort of, piling inference upon inference in a way that just is not, ultimately, just for Mr. Compres. But I think, it's certainly a fair question. And the way I would look at it is, I just don't see how any intent is formed on the resisting charge. So I think the resisting charge is problematic as well. So I've discussed the McDowell case and would apologize that in terms of the exact mind state for resisting, I don't have it at the tip of my tongue here. But I just think, again, looking at the video, I don't see where the intent, we don't know when he was told you're under arrest. And this happened so quickly. It's not clear to me he's resisting. I mean, I find it troubling. I feel like if any of us were in this situation, for whatever reason, we would somewhat try to protect ourselves. He's frightened. He's being absolutely manhandling. I don't think that rises to the level of resisting. This isn't 10 minutes of a guy sort of writhing around and attacking police. This is seconds. This is probably 5 seconds when this very slight young man, he's frightened, he's terrified, he's dragged. I mean, there's not a lot of resisting going on. He ends up almost with a broken head. And if his head had fallen a different way, we'd be, talking about something very different. So I think this vandalism was overcharging. I don't think, yes, sure.
Sorry to interrupt you, but I have one question before you run out of time.
Yes,
so with respect to the vandalism, as I understand your argument, it's essentially that looking at the video, we don't specifically see any tearing of the clothing. My question for you then is, if there is evidence that your client did tear the clothing, the officer, is that in and of itself sufficient to prove vandalism under the Lattimore standard?
Not under these facts whatsoever. The testimony is insufficiently vague, and the video, I think, is exculpatory, Your Honor. We see everything. It's just literally seconds. How do you rip someone's jacket?
So my question is a little bit more specific.
Sure, Your Honor.
Perhaps a little bit more obtuse from your perspective, but I'd still like an answer, which is, if there is evidence that your client tore an officer's uniform, tore his clothing, is that in and of itself sufficient to prove vandalism under the Lattimore standard?
I would say no, Your Honor, but and I apologize for not being direct, but I would have to think it's what kind of evidence, what quantum of evidence. I mean, your question is very broad. If there's evidence, and I think in any case, be it civil or criminal, there's always going to be a question of the quantum of evidence. And under Lattimore, it's due process. It's a constitutional right to have sufficient evidence. So, and I think you have to look at the totality of the evidence. So even if we sort of credit that, hey, this jacket was ripped, you have to look at mind state. You have to satisfy the mind state of wantonness. And you have to look at all the evidence, Your Honor, would be my response.
And unless the panel has any other questions, seeing none, we will have to leave it there, Mr. Hahn. Attorney Ochtring, when you begin, the clock will start.
Thank you. May it please the court, again, Susan Ochtring on behalf of the Commonwealth. As several justices have indicated today, the court will review the evidence in the light most favorable to the Commonwealth. Here, there were 2 witnesses, both who were in the lobby with the defendant, as well as the video. And contrary to defense position, the video too is viewed in the light most favorable to the Commonwealth. Defense
You would agree, though, we don't see the pocket tearing on the video.
The only one, I'll be happy to answer the question. I was going to go through it on the video at well, first when my brother says that the defendant is walking out on his own accord, he's on his way out. I submit with the testimony of the officers in the video, he is not on his own accord walking out. He's being escorted out. There's one officer who has him by one hand, and that's it. The other officer is not even touching him.
Oh, wait, he's being escorted out, or is he being under arrest at that point?
Justice Massing, I believe the first lieutenant who testified, Basalt, originally on direct said he told him he was under arrest in the lobby. On cross, he was shown his police report and refreshed that, oh, okay, no, we were bringing him out and it was in the vestibule. That is when we now told him he was under arrest. So his initial testimony, I think he just didn't remember it correct until he was shown his report. And then he
So
said,
the time, there's no audio on the video.
exactly.
You're saying that the time that under the cross-examination, the time that he communicated to the defendant's under arrest was during that, what's shown on the video.
I don't think I caught the last part of your question.
I think you said that somewhere during that video is when he's told he's under arrest, not before the video begins.
Well, I don't mean it like that. I think the video shows from the very beginning, the defendant is in what we call the lobby, which is where everything started, is where the defendant was telling the officers, even though they said your business is done here, it's time to leave. He refused to leave. He refused to leave. So sticking with the audio, if I may, at 17 to 18 seconds in, again, he's still in the lobby. You see the officers go around him. At some point in part of the view, which I mentioned in my brief, is obstructed because of the top of the door frame. You can't see, but you see a movement by the defendant, like he's pulling his hand away. At that point, again, if you kind of put the audio together with the officer's testimony, now they decide he's refusing to leave. They've told him to leave. He doesn't belong there. So now they're bringing him out. Not four officers, I would say, if you look at the video, they're not all.
They're not arresting him. They're not arresting him. They're bringing him out.
I don't think they are at that point. I think they're bringing him out. At some point when they reach the vestibule, now you see the defendant spin away. And he starts to spin and twist. And that's what Officer Foley testified to, that I grabbed him by the arm and said, it's time to go. We went for the door and he started to pull away from me. We made it to the foyer. He started to spin. That's when they told him he was under arrest. So they're bringing him out to the parking lot, even though they could have arrested him for trespassing at that point. And you can see at 22 and 23 seconds in the video, he does spin multiple times. Now, presumably, again, we don't have the audio, but if you view the evidence with the audio together with the officers, now they say with all this spinning, they're putting him under arrest. He continues to spin. It now takes more officers to finally put the handcuffs on him. At 26 second mark, you see the defendant spin again and his right arm reaches towards one of the officers' shoulder or arm. It looks like he has a jacket on. That, again, is possible in light of the testimony, and Lieutenant Basalt said that the defendant used his right hand and saw him tear the pocket. I mean, if there's a pocket on the arm, that's possibly where it happened. I mean, I don't think in the light most favorable to the Commonwealth, we need to see exactly on the video where the tearing was. The question is, was his conduct wanton in marring the property of another? And I would submit his refusal to leave after multiple times being told, his spinning and grabbing and twisting and pulling away from the officers was intentional conduct, which led to the destruction of the property and constituted resistance.
So that even if he didn't intend to rip the pocket, it's your view that the scene, if you will, that he created, and as a result of his actions and behavior in that foyer, something was ripped, that is still vandalism. It wasn't incidental, accidental, ancillary. It was a crime in and of itself.
That's exactly it, Your Honor. And I think the video shows that. You don't see him, maybe getting pushed and accidentally doing something. You see him multiple times twisting and pulling and spinning to avoid this effort to arrest him. And at one point he does reach out. I think the officers, I don't know who the officer is, and the officer who was identified as having his pocket torn was not one of the ones who testified, but there is an officer. And at one point, again, it's the 26th mark, you see him, the defendant twists, he comes face to face with an officer. We only can see his back. And you see the defendant's right hand reach out and almost touch the sleeve of that presumably
Can I
officer.
ask you some questions about the vandalism charge? First of all, why is this vandalism at all? There's no painting or marking or scratching or etching or marring or defacing. Why is this a vandalism charge?
I would submit that marring of a uniform is vandalism. It's destroying property.
And aren't there other crimes for destruction of property?
Well, there are other crimes, but this is what he was charged with, and I think it was a proper charge. In the case I submitted, it's an unpublished case. It's Commonwealth versus Bath, which I'd submit is even less damage. I think it was bottles knocked over in a store, and here we have testimony of a ripped.
I was on that panel, and that involved video too, and there's a lot more damage in that case. But the thing was, in that case, the defendants were actively going after a rival. They were actively going in. They followed him to beat him up. Here, the defendant is involved. He didn't? I mean, yes, he engaged in inappropriate conduct in the police station, but the marring of the property occurred as he's resisting arrest. It doesn't have to. I mean, it doesn't have to be, wanton intent. It's not just negligence. It's not just it's not just but for cause. There's got to be wanton intent.
Right, well, the conduct itself is a general intent. So if what he's attending is reaching out, and the testimony of Lieutenant Basalt was he was grabbing, clutching the clothing. So I think that testimony, again, viewed in the light most favorable to the Commonwealth, whether he was trying to grab onto that pocket and purposely rip it, he was resisting, he was reacting, and you can see on the video, he's reaching out, he's twisting, turning, and his arms are reaching out towards an officer.
Well, in closing argument, the prosecutor says that the defendant was, quote, indifferent to the probable results of his action, and that's why it was a vandalism. Is indifference enough?
Well, indifference, it goes to the intent that the act was done with an indifference to or disregard for the probable consequences. So he was indifferent.
I assume you didn't go on a willful and malicious prong. You went on a wanton theory.
That's what it appears, Your Honor.
But wanton and indifferent, are those the same thing?
Well, I think indifferent is in terms of what's the result of his wanton conduct. I mean, what was his general intent? It was an indifference to what could happen when he's engaged in all this physical activity that he, like if when he, let's say he tripped at one point, you see during the scuffle in the vestibule, the rug or the mat gets lifted up. It gets, it was lying flat and somehow it gets lifted up. That would be accidental, I would say, if someone tripped over a mat because it's part of the scuffle. Here, though, the testimony was and again, you can see it in the video, he's reaching out with his hands, fighting these officers, pulling, grabbing at whatever he can, and that is an intentional conduct with an indifference to what could possibly happen.
Does our case law define wanton in the context of the vandalism statute? Can that be found in any published case?
That, I believe, is the McDowell case. A wanton is an actor has an indifference to or disregard of the probable consequences. It's a general intent crime.
I would ask what the judge instructed here, but this was a jury waived trial, correct?
Yes.
So in any event, we presume that the judge correctly instructed himself.
Yes, Your Honor. So for all those reasons, and again, I do think that the video corroborates as best possible. I mean, obviously, we don't have every angle. There's no audio.
What if during this incident, instead of ripping the pocket, he was flailing his arm and it hit the police officer. Would that be an assault and battery on a police officer? If it was incidental to what was happening in the foyer?
I guess it goes to what the fact finder determines whether it was intentional or not. In terms of, I think the question was assault and battery.
Right.
Yeah.
So he didn't intend to hit him, but in the context of resisting arrest, he struck the officer. Is that different than what happened here with the pocket?
Well, I think it's different. I mean, I think in this case with the resisting arrest was the spinning and the pulling away, is from what I understand. At some point, he reaches out and grabs the pocket. It doesn't matter that he didn't mean to tear it. It's just he meant the conduct that which he did. And that was the testimony of Basalt. And again, to look at the video, and then I think the question was asked, can we see the tearing? And I submit you can't see the tearing, but at one point I did see, and it's consistent with Lieutenant Basalt's testimony when he was shown the video at trial to show where it was that you saw the tearing. And he says, well, I think it was, he used his right hand. And my memory is from the video, you see the right hand reaching out and he's grabbing on, which is consistent. Well, I can't say in the video you see him grabbing on because it's not 3D or something, the dimension. You just see his right hand towards the shoulder of an officer. And again, in the light most favorable to the Commonwealth, it's possible that that is where the tearing happened. But again, I don't even think you need the video when you have Officer Basalt's testimony. If there's no other questions, the Commonwealth will rest on its brief.
Let me just check with the panel.
No, thank you.
It looks like there are no further questions, so we will deem the matter submitted, take it under advisement. I thank you both.
The case is now being live streamed.
Thank you so much. The next case that we're going to hear this morning is Commonwealth versus Davidson Altimo, docket number 19P728. Attorney Green, you may proceed when you're ready.
It may please the court, Bruce Green on behalf of Davidson Altimo, the appellant in this case. And this is a case where there was a suppression hearing and my client subsequently did a plea pursuant to Gomez. So the only issue is a narrow one regarding the suppression related to the stop of the motor vehicle. The reasonable suspicion in this case was at least partially determined by a tip from an informant. And I would suggest affirming the judge's ruling in this case would amount to eviscerating the requirement for a basis of knowledge or reliability when it comes to it.
This though,
Yeah.
I understood that to be the argument in your brief, but we know who this is. This isn't an anonymous tipster. Doesn't that change the calculus?
It normally would. And I know that the Commonwealth relies on the fact that this tipster is known to the police. However,
Well, it's known to
I would
everybody.
say he is, but the reason that we give, I'll just say, a free pass on reliability to a known informant is because when a citizen comes forward and volunteers information to the police, they put themselves at risk for charges of filing a false police report or other wrath of the police for giving them wrong information. In this case, although the informant was known to the police, he did not come forward. He was, I'll just say, enticed by the police to try to give them information. It was only when they promised him anonymity by saying, we won't say anything, that he spoke. So this is hardly the situation where a citizen witness comes forward and subjects himself to the perils of supplying false information to the police. And also
Well,
not to,
you prefaced that by saying that he would be in trouble for if he made false testimony. The police, an anonymous person, they wouldn't know, but that still applies here. Whether they say they'll keep it quiet or not, if they don't like his information, they can still punish him for that. They still know where to find him.
obviously they could, certainly. However, when it comes to the reliability of the information being provided, if the tipster feels that he's not, and again, whether the police could do it or not, is another question, but if the tipster feels like he's in a safe zone, and I believe that's exactly what the police tried to do in this case by saying to him, we won't say anything, they're encouraging him. And also, the tipster in this case was involved in a shooting. That's why the police were talking to him. In the shooting of Mr. Altimo, somebody that I'm just going to say, I think it's pretty clear he didn't like. So giving information that said he was involved in a shooting, I think would be suspect just on that basis. But I don't think this amounts to a citizen, a witness citizen coming forward to provide information. I think he was given a special security blanket by the police to say, you don't have to worry about what you say. So I don't think that the reliability should go automatic.
And I apologize for interrupting. It's difficult to communicate on Zoom, but in any case, I want to follow up on Justice Blake's question, and that's this. You're calling this a tipster case, and perhaps it is, but it seems in such cases, the concerns expressed in the case law are twofold. One is we're concerned as to whether or not a crime is really being committed or has been committed. And the second concern is, does the information provided to the police have a legitimate and corroborated basis? And here we know a crime was committed because the victim was shot, and we know he was shot. And here, there's also not only evidence of a crime being committed, but there's evidence that the witness was present at the location of the shooting, either during or at least in the immediate aftermath of the shooting when the police arrived there. And on top of that, we have the corroboration involving the motor vehicle. So with all of that corroboration, do the tipster cases that you cite in your brief, they seem, at least if not an opposite, to be perhaps slightly off point. So could you address that concern that I have here?
Yes, there's certainly information that that the tipster, the person given the tip, was present at some point after the shooting. I would say immediately after is too strong based upon the evidence. The police that testified at the hearing were not the first police on scene. They arrived sometime afterwards. They couldn't say how long afterwards. They were asked on cross-exam if they were there within 2 minutes, and they said no, absolutely not within 2 minutes. So at some point afterwards, he was there. The victim in the case told the police that he was outside by himself. So obviously there's other people that were outside on the planet at some point in time, but there's no information that that Jesus Oquendo was with the victim or even in a place to observe. Certainly it's possible, but I don't think possible is the standard. Obviously any tip needs to be possible to be relevant, but it needs to be a reasonable inference. This judge just contradicted himself. He initially said to draw such a conclusion would be conclusory and could just be rumor, but he reversed himself on that and inferred that this was based on firsthand knowledge. There's really nothing in the record to support that. And actually the victim saying he was outside by himself contradicts that.
The questions that you're raising about what Jesus did or didn't see and how far he was and what the timeline was, why doesn't that all go to his credibility at trial? I'm having trouble following you as to how that goes to the motion to suppress issue, where, as Justice Neyman just pointed out, this is not your typical tipster case. And as Judge Massing pointed out, he was not filing a false police report. The police went to him.
Certainly, but even if the police go to somebody, if they provide false information, they would be subject to that. But
Sure.
the other part, I know that there was a certain amount of corroboration, and that the police saw that a gray Nissan was involved, and that Mr. Altimo had in fact access to a gray Nissan. And I'm just going to suggest that that's not an adequate degree of corroboration. And I know the Commonwealth relies on the Burt case, where there was information received by a security officer that parking meter officials were stealing money from the parking meters. And there was an extensive 5-month investigation, observations of the individuals involved, moving heavy objects from the cars, their work vehicles to their private cars, which were not parked on company property, and moving heavy objects to their home. In this case, the corroboration amounted to nothing more than determining that Mr. Alt had access to a gray Nissan. The
But it's
police
more than
admitted
that,
there's
right?
many gray Nissans.
I
I know that they indicated that this was
it's the color, it's the appearance, it's registration to his girlfriend, it's him having access and having been seen using it and then being a passenger in it. It's not just a gray Nissan, is it?
Well, it is. I mean, I know they know who it's registered to, but they didn't know the registration number of the vehicle that was involved in the shooting. So the fact that they know the registration number doesn't get them any closer to that vehicle being the one that was involved in the shooting. And again, it was not his vehicle. It's just something that he had been in a month before this shooting. And I know the Commonwealth also
Actually, can I ask you about
makes light that these were
Mr.
rival
Green,
gangs.
Attorney Green, can I interrupt you a second? I'm sorry about that. In terms of how many
Sure.
times he was seen in the vehicle, I think there are 3 times. Is that right? Am I reading the record right? You say in your brief that the police had information that he'd been associated with the vehicle once as a driver, once as a passenger, and then he's taken to the hospital in the vehicle. So are there 3?
I'm not certain there's evidence in the record that he was taken to the hospital in that vehicle. I believe Officer Canini was very emphatic that he did not know anything about how he was taken to the hospital. There was some talk that there was a video of him being brought to the hospital, but that he had never seen that video, so didn't know. So I know the Commonwealth also makes a point that these were rival gang members, and so that there's inferences to draw from that, but I would say that that could cut the other way as well, that being rival gang members, there's perhaps many other individuals that could have been responsible for the shooting. But I also know that there was nothing beyond that they're in rival gangs, and also that the victim of the first shooting was not a gang member. It was his older brother, Victor, that was verified to be a gang member, not the victim of the shooting. But I know the Commonwealth relied on the Corradino case to say that the ill will between them allows you to draw inferences. But in Corradino, it was a much stronger, the 2 parties there had been involved in several called bad arguments, involved cheating in an illegal card game. Here, there's nothing more than saying they were members of rival gangs. So I don't think that rises to the level to add to the corroboration here. But I realize that, I'd always like to say it's a bad coincidence that it's a gray Nissan, but it is. There is a lot of gray Nissans around. The officers said it matched the description, and I know there was some testimony regarding the taillights and the grille being similar, but the officer also admitted that he was not an automobile expert, and they didn't seek one out to try to verify that, to narrow down the available gray Nissans that are out there. But I think the judge's finding that this was based on firsthand knowledge is clearly erroneous. And And I realize that he is a known informant, however, not in the classic light of things, and only became an informant after the police gave him assurances that they wouldn't say anything about anything that he said, which is not the classic informant coming forward to put themselves at risk. I don't think that the corroboration here amounts to the cases the Commonwealth relies on. I don't think it's sufficient here. So given that the informant had no basis of knowledge or reliability, and the corroboration is insufficient, I would ask the court to reverse the trial court's holding in this case.
Are there any other questions from the panel?
Thank you.
Okay, we'll take the rest of your argument on your brief.
Thank you.
Attorney O'Sullivan, when you're ready, the clock will begin.
Thank you, Your Honor. Good morning, and may it please the court. Shane O'Sullivan for the Commonwealth. The Commonwealth's position stated in our brief is that reasonable suspicion existed to stop the defendant's automobile based on the tip that came from the identified informant and the corroboration that shored up that tip.
So how did the fact that the tipster was known and identified change the calculus here compared to what your brother suggested at the end of the day, there wasn't enough corroboration?
Well, it adds reliability and facts upon which the judge could properly find, on certainly under the clear error standard that this court must evaluate it, that the informant had personal knowledge through firsthand observation.
Didn't the judge say something to the contrary, though, before he ultimately made that finding?
I don't know that there was a contradiction, Your Honor. And you'd have to remind me of the language that is the proposed contradiction. My reading is that the finding that Jesus had viewed that through firsthand observation was pretty clear. And there were record facts to back that up. The support for that personal knowledge finding, this September 27th shooting happened during daylight hours. The officer, Canini, who responded to them. He couldn't give an exact time frame, but he testified that he responded to the 911 call from approximately 2.5 to 3 miles away. The victim located on the sidewalk, the tipsters on an open second floor balcony at that time. It certainly wasn't maybe absolute certainty that the tipster had viewed or had firsthand observation of the shooting, but we rarely deal with absolute certainty in fact finding, and there was certainly evidence from which the judge could properly draw that conclusion. I would point to the Stout case on this point, which, you know, is normally cited for our divergence from the Hodari D standard, but the second half of the Stout case, I feel, is actually extremely applicable to the instant circumstances in this case. And Stout describes what they quote as a, quote, probable basis of knowledge, close quote. And I would suggest that that's really what we're dealing with here, is what was the probable basis of knowledge that the motion judge could draw from this tipster.
Mr. So let me ask then, if suppose we find that it is clearly erroneous that this was based on firsthand observation, and instead we conclude based on the evidence that this is based on secondhand observation. You know, it's his brother after all. Would you still have reasonable suspicion if those were the facts?
Yes, I think you could. And furthermore, I think you could have reasonable suspicion just on the tip. And the reason I say that is that the reasonable suspicion calculus from a tipster depends on basis of knowledge. Now, the cases say that basis of knowledge is usually satisfied by personal observation or firsthand knowledge. But I do not believe that they say that basis of knowledge can solely be satisfied through firsthand knowledge and personal observation. And courts do allow sometimes evidence in, even in a trial context. I can think of, business records or medical records come to mind immediately, where the testifying party certainly doesn't have personal or firsthand knowledge, but for other reasons, it is reliable. And with the corroboration that was present in the instant case, I would suggest that the tip, even if this court were to find wasn't based on firsthand knowledge, was still reliable. The perpetrator's motor vehicle matched in color and appearance with one that the defendant had been stopped in just 1 month prior, which was a motor vehicle that was registered to his girlfriend. Now, granted, the registration plate couldn't be seen on the video that identified the crime, but still based on an officer's analysis of the body type. He said he looked at the grille and the fender. They all seem to match this Nissan Altima. And the question in corroboration is really whether the informant provided reliable info. And it's answered by looking at all of the circumstances. The additional circumstance that there may have been animosity between these parties, I would not minimize that to the extent that I feel maybe my brother has minimized the gang involvement in this case. Yes, Victor Oquendo, the eldest brother, was the only verified gang member. However, there were persons present at the associates of his present at the September 27th shooting that then are at the shooting 3 days later. Based on the informant's tip, it appears that that shooting carried out against the defendant was retaliatory. And I would suggest that in these circumstances, it was a reasonable inference for the officer to make and for the judge to make that.
Actually, doesn't that same argument cut against you? And Justice Neyman was asking Attorney Green about this. The reason that we have the Aguilar-Spinelli test is to ensure that there was it's a real suspect, a real crime. And if it's motivated by, so it's not, Jesus is not the victim. He's not the gang member. Those are his brothers. Is there a way of looking at this that he's actually they're fingering an enemy?
Well, Your Honor, I would say that, he's fingering the enemy after there's been this retaliatory shooting. And what I would say is the retaliatory shooting is kind of the corroboration here, that if the gang which Hector belongs to then carries out a retaliatory shooting on the defendant, the inference, I would suggest that reasonable inference based on these types of situations is that there's a correlation there. And I don't think that the motion judge, to the extent that they relied on it, would be making too big of a leap to make that inference. And I do feel as that element of corroboration adds, although it's important, it probably adds least to the calculus of corroboration. I think the motor vehicle aspect is much more persuasive. There was no way that Jesus could know at that time what that surveillance video from the September 27th shooting would have conclusively shown. Yet he fingers the defendant, and sure enough, the surveillance video reflects a car matching one the defendant had access to. So in my view, that was...
Tell us how many times the defendant was seen or affiliated or associated with this gray Nissan.
So if you exclude the September 27th shooting incident as, okay, then we had 1 month prior, he was stopped operating that motor vehicle. I do believe that the record would reflect that that was the same vehicle which had dropped him off at the hospital on September 30th. There's the actual date of the stop where he is observed in the vehicle by the detectives, which is kind of almost a happenstance type encounter. And there may have been testimony that there was one other time, but prior to the September 27th shooting, but I can't be, I'm not certain as that. I know there was at least the one time where he was stopped as the operator of the motor vehicle 1 month prior.
And the fact that the motor vehicle was registered to his girlfriend?
Yes, and the fact that, exactly, the motor vehicle was registered to his girlfriend. I would like to briefly cover the issue of whether Jesus was a named informant or not.
Sure.
I would point to the language in the Alfonso case, which the Commonwealth has cited in our brief. And the language that I think is most important is what Alfonso says is, quote, untraceable, unknown, quote, informants may lack that reliability. And I would suggest that this informant was not untraceable or unknown, even if he relied on an assurance that his tip would be held secret. He still at that time knew that he was identifiable. The officer.
What's the pin site of that quote?
Your Honor, I apologize. I don't have the pin site for that language. I know it came from the Alfonso case. And I believe it cited it with a pin site in the brief, and I would be happy to follow up with the court.
That's okay.
But he still knew he was identifiable. This was not an anonymous tip. He had been located just that day on the 30th. Police had located him through viewing surveillance video from a local business, had pulled him aside relatively quickly from after that second shooting had occurred. So he certainly knew that he was identifiable. This was not, just an anonymous person calling into a tip line. And for that reason, I think it's imbued with additional reliability. Furthermore, by being named in the grand jury or whatever, however probable cause was first pursued, by being a named informant, he's open to investigation by the defendant, cross-examination at some point potentially, and so that also, I think, adds to his reliability as well. So I would not, I would underscore that the reliability of this informant was based on him really being truly named, and any assurance he had that it would be kept secret really, I think, diminishes from it minimally, if anything at all. If there are any further questions from the court, I'm happy to answer them. If not, I would rest on the brief.
Seeing none, we will take the matter under advisement. The case is deemed submitted. Thank you both.
I will.
Thank you.
The case is now being recorded.
Thank you. Our next case is GKS Nominee Trust and others versus the 603 High Street Condominium and others. Docket number 19P1626. Attorney Erickson, when you are ready.
Thank you, Your Honor. Good morning. Good morning, Your Honors. May it please the court. My name is Scott Erickson of Perkins and Ansel, and I represent the appellants in this matter, GKS Nominee Trust and the Sullivans. Your Honors, the case before you today presents a question of document interpretation. Unfortunately, we believe the trial court's decision creates more questions than it resolves.
Before we get to the substance, I did have a procedural question.
Yes, Your Honor.
It appeared from the docket that there are some unresolved counterclaims. So my question is whether or not this appeal is properly before us at this time. Can you resolve that issue for us?
Yes, Your Honor. We believe it is, and particularly because the counterclaims relate in part to the declarant's reserved rights in this case. So until such time as those rights are resolved finally, one way or the other, we believe it would be improper to attempt to resolve the counterclaims advanced by the unit owners.
Okay.
So briefly, Your Honor, as I was saying, the facts of this case are relatively straightforward and not in dispute. Our clients, the appellants, created a 2-unit condominium in Medford in 2017, the 603 High Street condominium. When they established the condominium, they also reserved certain rights and easements under the condominium documents there.
Let me stop you right there. You say they reserved an easement, but the master deed uses the term hold and transfer, and in the future transfer, correct?
Yes, Your Honor.
Are there any cases interpreting the term hold as used in this context? And by that, I mean in a deed or in a real estate conveyance or in a land use context?
We scoured
I know that you quote Black's Law Dictionary, but any cases?
No, sir. And I appreciate the question. I mean, we scoured the case law in the Commonwealth to see if we could find the silver bullet that links hold to an easement in gross. However, I think, and we'll talk about this a little later, but I think when you look at this case, particularly in light of Hamuda versus Harris, you have to take a look at not only the explicit language in the documents, but the attendant circumstances. And that's precisely what Hamuda says, is that the attendant circumstances of the reservation here inform the scope of the reserved right. And I think that more importantly is the inconsistency of the trial court's conclusion. If one has a right to hold and in the future convey an exclusive interest, how can that right be of any value at all if that individual does not have the right to protect and control that in the interim? And that really is what this case comes down to, Your Honor. Essentially here, if the declarant has no right to control to the exclusion of others, that parking space, how can it truly be said that he has as the trial court did, quote, unambiguous right to transfer exclusive use of that later on?
Let me ask you a question. As I read your brief, I think you said that hold in this context means to possess. Is that correct?
That's correct, Your Honor.
Okay. How do you square that with the fact that case law indicates that an easement is a non-possessory interest?
Well, I think, Your Honor, in this case, so the definition to which you refer and which we did cite in our brief was from Blackstone. I think that to hold as in an interest in real estate here is really to control. And
well, let's before you get there,
sure.
You said possess, and I'm not trying to be nitpicky, but do you agree at least that possess is sort of the antithesis is strong, but possess is inconsistent with what an easement really is. Would you agree with that?
I do agree with that, Your Honor. Obviously, the nature of an easement is, to have a right over a land that someone else possesses. That's the very nature of an easement. But here, I think, the Blackstone definition also relates to holding title. And here, I think that really means control. And I think, again, it comes down to this notion that, if the trial court concluded, as they did, that the declarants here have an unambiguous reserved right to hold and in the future transfer, we have to decide what does that mean in this context. And if there's no control now, if the current unit owners can use the parking space however they wish, then that reservation is meaningless. It's a phantom right. It's a right in name only. And so it has to be that, as Hamuda says, you look to the attendant circumstances. And particularly here with the reservation language that's in the master deed and which is buttressed by the clear depiction on the site plan of the reserved space, that the declarant meant to hold and control this space pending its future transfer.
My understanding of your argument, excuse me, basically your sole argument in your brief as to this interest is that it's an easement, correct?
Yes, sir. An easement in gross.
Please take this as a hypothetical because we have certainly not decided this case. But what if we decided that we agree with the judge that hold does not constitute an easement in gross? It might mean something else, but that we think the judge was correct and it is not an easement for the reasons the judge stated and the reasons in the case law. Where does that leave us?
I think that leaves us, Your Honor, still with the position of cleaning up the trial court's decision to say, okay, this reservation, the trial court acknowledged, means something, and the declarant does have a right to transfer. So that has to mean something. There has to be value. Roseo says clearly that there's value in these reservations, taxable value in that case. So the declarant has to have a right to be able to sell this to the unit owners who currently reside or who in the future reside at the condominium. And to do that, he has to be able to control it in a way that the current unit owners do not derogate that right, do not by their own use and effective control, make the right meaningless. So
the judge did not determine I believe it was her decision, the judge did not determine whom, if anyone, had the right to use the space, correct?
Correct, Your Honor. And that's part of our concern.
Understandably. So my follow-up to that is, am I correct that the unit owners by definition need to cross over at least a portion of the space in order to get to the garage?
No, sir. The space is 10 feet wide in a common driveway that might be 20 feet wide. While certainly it would be most convenient for them to be able to not have to worry about being over that, it would be possible to travel from the street to the garage without crossing over that reserved space.
Sort of strange for someone to reserve this right in a master deed without sort of explaining that interest in the sale, either in the purchase and sale agreement or in the transaction. This is sort of I use the term strange, maybe unique is better phrased.
I think, Your Honor, it could have been clearer. I don't disagree with the trial court's conclusion there, but I think the intention of the developer, as evidenced from the actual language and from the attendant circumstances, was there's an additional space here. That space has some value. I would like to be able to sell that space for that value to one of these unit owners if they wish to purchase it. So, I think it's that simple. I agree that this could have been done in a way that, we wouldn't be here today, but unfortunately the documents are what they are. That said, I think the documents provide pretty clearly for just that right, the right to hold and sell in the future.
So if the judgment stands, what happens to that space? If we affirm, what happens to that space?
If it stands as written, Your Honor, I don't know. That's part of the problem. I think, to be honest, the dispute continues because at that point, I suppose the unit owners would take the position that they have the right to use that space. They don't have the right clearly to the exclusive use of the space under Section 13 of the master deed because that was reserved to the declarant to transfer. The trial court agreed. So
that the unit owners could live in the units and then your client could sell the space to some random person?
No, Your Honor, because Section 13 of the master deed does specifically say that the space has to be transferred to a unit owner. But in the future, if another unit owner came along, not one of the current appellees, it could be that the declarant sells to that holder.
So you say that, I'm sorry, Justice Blake, you go ahead.
No, go ahead.
It was massing, but
Sorry, Justice Massing.
I want to clarify your position. You're saying that the hold would, you'd say that your clients have a right to protect and control or hold and control the space, which is exclusive, does not allow the other part, the unit owners, to use it, but doesn't allow your client to use it either.
Well, and that, to be honest, Your Honor, is obviously not our desired outcome here. We think that the right to hold is more expansive, certainly than what the trial court concluded. But at a minimum, my position is that, in order to transfer exclusive use to someone else, you have to be able to control that exclusive use. And if you can't, then you have no right to transfer it.
I have two additional questions. And the first is, you say that to hold and have the right to ultimately transfer has to have some meaning. Why couldn't the meaning be that one of the unit owners has the authority to purchase the space from your client to the exclusion of the other unit owner?
That certainly could be the meaning, Your Honor, but until that point, until that purchase, and both of these unit owners have declined to purchase it. And quite frankly, why would they? If right now they're able to effectively use the space, why would they pay any sum of money to secure the exclusive use of it?
To use it to the exclusion of the other unit owner for whatever reason. Maybe someone wants to park close to their unit and doesn't want anyone else to park there. But doesn't that at least provide your client with the potential value that you say is absent in the current interpretation?
I don't think it does, Your Honor. And because of why we're here today, where we have two unit owners who are co-appellees who have decided as between them, we are better off together than apart, and can effectively control this common area to the detriment of our client who reserved a right of value.
Aren't you going beyond the plain language now of the wording in what I would call the wording of the master deed and saying, well, under these circumstances, it has no value, but it could under other circumstances? I don't think we can go that far in our interpretation.
Well, sir, no, I don't think it really goes beyond the plain language, because again, to hold and in the future transfer exclusive use has to mean that until pending that transfer, we have the right to control that exclusive use. And we don't right now, not as the trial court's decision is written.
Okay, so my other question is this. So the judge at summary judgment, I'd like to get to what the judge did not address, just so I understand procedurally where we are. The judge did not decide your claim of trespass, correct?
Correct, Your Honor.
The judge did not decide the opposing party's claim of trespass.
Correct, Your Honor.
And the judge did not decide the remaining counterclaims
That's
that
right.
are still pending, but is the status of them that they're on hold pending this appeal?
Yes, Your Honor.
Okay. Did I omit anything? Is there anything else that the judge did not decide at summary judgment?
No, Your Honor.
There's a third party claim, isn't there?
The third party is just a mortgage holder, I believe, Your Honor. They've not taken any active role.
But there is a third party claim for a 93A against the broker.
Oh, yes, Your Honor. Yes, that's right. I'm sorry about that.
Also not decided.
Correct.
And there's no separate and final judgment as to the summary judgment that was issued.
No, Your Honor.
54B. And you suggested at the beginning that there's an exception to the 54B rule when deciding that case, the summary judgment issue is preliminary to other issues.
I think, Your Honor, that's right. I don't see how these other issues can be resolved without a resolution on the declarant's reservation here. Your Honor, briefly, I'm sorry, I didn't mean to interrupt you.
So the 54B claim is not raised by the defendant, is not raised as a defense, so they didn't have a chance to respond to it. So you're kind of going off the seat of your pants there, actually. That's your guess.
Your Honors, very briefly, I know I have very limited time here. I just wanted to quickly address the frivolity claim in the appellee's brief. Clearly we think that this is an issue that's worth your consideration, and don't think it's frivolous. There is, a reason here that we're here today, and that is because we think the trial court's decision is unfortunately at best unclear as to the declarant's rights. So obviously we oppose the request for sanctions.
Final question for me, is the commercial wharf case 407 Mass 123 the controlling authority here?
I think it's one of the controlling authorities here, Your Honor. I think CBK Brookhouse is also a controlling authority. I think Roseo cites them both and neatly summarizes it.
So those three cases?
Yes, Your Honor. And,
Thank
and
you.
as I said, Hamuda, I think, is a very instructive case in terms of interpretation.
One more just brief question. How much is this parking space worth?
I don't know, Your Honor. And that is a great question, and I should know the answer to that. I don't. We have not had it appraised. I think it's of limited value because it can only be sold to one of two owners.
Wasn't there testimony that your client offered to sell it for $25,000?
There is, yes. But, in terms of whether that's the value, I don't know. Like, we have not had it appraised.
That doesn't strike me as minimal value, but I don't live in the city anymore these days, so perhaps it does.
Does the panel have any additional questions? All right, seeing none. Attorney Fulmer, when you begin, the clock will begin.
Thank you, Your Honors.
Thank you all. Good morning, Your Honor. And I thank you for the opportunity to partake in this proceeding. We have filed our appellate brief, and I incorporate each of the arguments that are contained in our brief. I do want to make mention of several factors which I believe are critical to this matter. First, it's our position, obviously, that the Superior Court judge ruled properly on the segment of the case that's before you. The plaintiff's case is one for a declaration, a declaratory judgment, and a trespass. The judge ruled properly based upon the language and applied the proper rules of construction, applying the paragraph 13 of the master deed and construing it against its drafter. That is the plaintiff in this action.
But where does that leave us? If this decision stands, who can use those parking spaces?
That's not a difficult question to answer, Your Honor. Let me see if I can analyze it. There's an improper conveyance here. First of all, that 10 by 20 doesn't even meet conveyancing standards. As far as we're all concerned, it's floating around on the map somewhere. It's not adequately defined. There is no conveyance deed to the trustees. There's a reservation. It says to
So
hold.
it doesn't exist.
It doesn't exist for all practical purposes. And my clients are the owners.
Can I go park there?
Excuse me, Your Honor?
Can I go park there?
Well, it all depends. You have first. Well, wait a minute. No, you can't.
Who can park there?
The owners of the property that have access to the property only, because no
And
one else
what
has
do you base that on?
the fact that this is a piece of property that is exclusively owned and controlled without the reservation of a proper easement to allow Mr. Sullivan access to his alleged reserved spot. He doesn't have access to the property.
Excuse me, but the judge did determine on summary judgment, or did declare, I believe, that GKS has the right to hold and at some time in the future transfer that space, correct?
That's correct, Your Honor.
And you didn't appeal that, correct?
We did not.
So what does the right to hold mean?
That because of the fact that they are no longer the management agency of that condominium, that they have no rights other than to transfer to the owners. That's all they have. They have no.
What does to hold mean? Does that mean they hold title? Does that mean, I know the judge determined it does not mean that they have an easement in gross. But she said they have the right to hold. What does hold mean?
To hold during the pendency of the sale. And quite frankly, given the nature of the organization, this is a two-family residential condominium, to be contrasted from that of the commercial wharf. They have a duty to convey it to the owners of the property in gross. You have two owners here that are paying taxes. There's no management vehicle for the ownership or maintenance or care or capital improvement or designation or right to pass over and use.
I understand that. I guess my question, what I'm getting at is this. At this stage, the judge held on summary judgment that they have the right to hold and someday transfer the space. If your clients have the right to use the space, then doesn't that mean that holding the space is just a nullity? It's meaningless?
In fact,
And if it is, that's a problem, I think.
Well, no, not really, Your Honor, because they haven't adequately defined, they don't even meet conveyancing standards. You couldn't identify the location of what they say they have reserved. That's the problem here. There's no proper reservation, there's no meeting of conveyancing standards, and there is no right to access. They have to go over my people's property to get to it, and that constitutes a trespass. So what do they have? It's a draft, admittedly, it's a drafting error. I don't know what they were trying to reserve, and I think based upon the relationship of the parties, it's my feeling that he was attempting to create something that he could sell later. But what he was creating was not adequately defined and was not properly reserved. It doesn't, and so it does not give him any rights to the property. My people.
I understand your position. The issue that we have is we're confronted with a judge's determination on summary judgment that is not being appealed, that there is a right to hold and in the future transfer. And we have to, under the law, give that some meaning. If the judge had resolved the issues that you describe right now, we wouldn't be in this position, but we are. So I'm just looking for some guidance to the extent you can provide it.
Well, Your Honor, perhaps I can. This is a very limited appeal, and the appeal in this case is on the plaintiff's issues. One, was there in fact, does the language of paragraph 13 comport with, as the plaintiffs suggest, the language contained in the commercial wharf case? Does it create an easement? And she emphatically indicated that the language is unambiguous. There is no easement here. The requirements are not met. Above and beyond that, the plaintiff's case is when are we trespassing? And she didn't have to reach that issue because there is no easement. There is no right conferred on the plaintiff to use that space and possess it exclusively.
So who owns it?
My people own it. By definition, by conveyancing standards, and by the law. They're the only ones that can own it. They pay taxes on it. They maintain it. There's no, Your Honor, it's
So
not
then you
even.
think Judge Kazanjian got it wrong too, right?
No, I don't think she got it wrong. I don't think she got it wrong. I think she got it right because she didn't have to reach the issue of how they're going to have to convey it. There's a 93A case
He
here.
gives the plaintiff's rights. Her final sentence in her order. The court further declares that the plaintiff's rights in the reserved parking space are limited to holding and transferring it as expressly delineated in the master deed. So they have an interest in that spot.
To hold and to transfer, Your Honor. And the language, again, is unambiguous. That's all the rights that they reserved.
So then they could sell it to me.
No, they couldn't.
Why not?
Because it's in the master deed, it can only be sold, or it can only be transferred, and it doesn't say sell.
Transferred to a unit owner.
Excuse me?
Transferred to a unit owner.
Correct. That's the only reservation that is contained in paragraph 13. And the judge made that specific. Again, this is not the entire case. This is the case limited to the plaintiff's right to determine whether there was a proper easement and as to whether the defendants trespassed.
Bear with me. So tell me if I have this correct. Your argument is the only thing before the judge, the only ownership interest that was asserted was an easement in gross. The judge determined there was no easement in gross. Therefore, the plaintiffs only have the right to hold or rather the appellants only have the right to hold and transfer in the future that space. And whatever hold means needs to be determined on another day and on another cause of action. Is that what you're saying?
No, Your Honor, I believe it's going to be determined in the remaining cause of action. In our case, for misrepresentation and under the 93A claim.
So would the judge have the authority in the remaining action to define and determine what is meant by hold and in the future transfer?
I believe she does.
So you would stipulate that that can be decided in the remainder of the case before the trial court?
I do, Your Honor. I believe we would, yes.
Okay.
Now, insofar as the balance of my argument is concerned, I do note for the record that the drawing on the plans that are annexed to and referred to as part and parcel of the master deed, they do not describe what brother counsel has suggested is more than 20 feet. It isn't 20 feet. And quite frankly, you can't put two cars side by side in that area such that my people have to cross over that land in order to get to the two-car garage, which is at the rear of the property. That's the first situation. So it's not it's a might be 20 feet doesn't comport with what the real plans suggest. There is, in our humble estimation here, an utter failure in drafting. This is not the commercial wharf case. The commercial wharf case is to be distinguished and differentiated. It was a split residential commercial use in Boston. Everybody knows the land. Everybody knows the piece of property that was put to the easement. And if you look at the use to which it was put, that company was to regulate parking and to sell and to lease and to, on a daily basis, utilize those that parking for, I don't know, customers of the businesses that were there or people who lived there. That's not within the realm of reasonableness of the use to which this two-family house in Medford was to be put. It's an entirely different schematic. So what you can't do is you can't read the commercial wharf analysis into the 603 High Street analysis. It doesn't meet it. It doesn't meet the criteria of what's required. This is a very limited piece of land, and the drafting, perhaps if the plaintiff had drafted, the right to reserve, to hold, to use, to pass over the common ways of the unit owners, that would have been a different ball of wax. But we're not dealing with that. We are dealing with an undefined 10 by 20 block, which quite frankly, again, as I've indicated, I hate to repeat myself, but doesn't even meet conveyancing standards. Nobody knows where the 10 by 20 is. And the plan, although it's a sketch, does not identify meets and bounds of where that 10 by 20 sits on the land. So what did he reserve? An imaginary 10 by 20 foot piece of land somewhere that these people now have to step around? It doesn't make sense. There's no logic in it. It fails under conveyancing standards. It fails under the definition of attempting to define and reserve an easement in gross. And quite frankly, given the nature of I don't want to go to easement by necessity, but it doesn't rise to that level because there is no purpose. There is no logical purpose for Mr. Sullivan using it as a parking space. And he knew it. He knew it. He did this for financial reasons. He thought he had a proper reservation, but he doesn't have a proper reservation. It isn't an easement, and it isn't well defined. It isn't properly defined or sufficiently defined to call it a reserved or exclusive space. And these people are paying the taxes. They're paying the maintenance. They have to repave that, Your Honor. They have to, it's part and parcel of the common way. They have to share in the overhead that goes with that property indefinitely for so long as they are owners of that property. I submit that the trial judge ruled properly and was limited to the issues. I submit that her care and delicate treatment of the issues was limited to those that were presented by the cross motion for summary judgment. We didn't move for summary judgment on the 93A. We moved in opposition to their claims and on our claims, suggesting that there was no trespass because they didn't have the proper rights. That's all we're talking about here. The trial judge.
Why do you think you're entitled to fees in this case?
Because it's frivolous. It's utterly frivolous to assume that they have a valid grant of an easement. The language is inadequate. It does not meet conveyancing standards. It was not filed in good faith. It was a misrepresentation to my people from the get-go because they weren't properly informed. That's part of our third-party claim against both the broker and against Sullivan, the plaintiff in this action, and the trust, because of the fact that they didn't properly disclose what they were reserving.
Is this appeal premature then?
Not insofar as the issues that are raised by the appellants, Your Honor. We believe that these issues are properly before you.
Does this issue need to be resolved in order to resolve the pending counterclaims?
I believe it should be. It certainly would lend the resolution of the 93A and misrepresentation claims in the Superior Court to a clearer outcome.
Attorney Fulmer, you agreed earlier that the judge in the remaining portion of the case I believe you stipulated that she has the authority to determine, or at least tell us what is meant by, or to tell you what is meant by hold and in the future transfer. I assume that the judge also would have the power in the remainder of the case to articulate who has the right to use or not use the space. Would you agree with that as well?
Undoubtedly, Your Honor. Absolutely. Absolutely.
Okay, I have no further questions, but thank you both.
Thank you all.
Anything else, Justice Massing?
Oh, thank you.
Right, we will take the matter under advisement. Gentlemen, thank you very much.
Thank you. The case is now being recorded.
Thank you. The last case of our hearing day today is the Stubblebine Company
The case
versus.
is now being recorded.
Thank you. The last case of our hearing day today is the Stubblebine Company
The case
versus.
is now being recorded. I believe one of the participants may have the YouTube channel on.
Today is the, if somebody has YouTube, possibly. All right, let's try that. So the Stubblebine Company versus Elaine, Linehan and others, docket number 19P1432. In this case, Mr. Guy, you are the appellant. So when you're ready, the clock will begin.
Thank you, Your Honor. Good morning, honorable justices, and good morning to my brother, Attorney Eisenberg. My name is Attorney Kyle Guy. I represent the appellants in this case, Mrs. Elaine Linehan, Mr. Jeffrey Linehan, and Linehan Realty LLC. The issue before the court today, Your Honor, is whether or not the trial judge erred in denying the appellant's motion to vacate a default judgment. We are here today to argue in the affirmative that the judge did abuse their discretion. Your Honor, this case arose out of a contract for the sale of real estate. Mr. Eisenberg's client was brought in as a broker to help Linehan Realty sell a piece of property located in Haverhill, Massachusetts. The parties dispute whether or not the ultimate buyer was exempt under that contract and whether or not the contract between the appellant and the appellee was actually terminated. The trial judge denied the appellant's motion to vacate after motion and argument, mainly because he found that the appellants were careless in that they did not file an answer within the appropriate time. He specifically, the trial judge.
It is a she.
Excuse me?
It is a she. Go ahead. The judge is a she.
My apologies, Your Honor. She found that my clients took no action. However, Your Honor, that finding is erroneous because the clients did take action. So this matter was filed on or about September 27th of 2018. My clients were served with copies of the summons and complaint on or about the first week of October. Within the 20 days, one of the appellants, the defendant at the time, Mr. Jeffrey Linehan, contacted the court and notified them that he needed more time to get a lawyer. During that, then pursuant to Mr. Linehan's affidavit and the representations of his counsel at the hearing, Mr. Linehan then contacted his insurance company. He sent a copy of the summons and the complaint to the insurance company and began cooperating with the insurance company on their defense of the claim. They
So
did.
at that point, though, whose obligation is it to take some affirmative action in the court to say, hey, I'm waiting to find out whether or not I'm going to be covered? Whose obligation is that, and what do you base that on?
Your Honor, that is a great question. And I would say that under
I
the
try.
under the facts and circumstances of this case, I would say that the burden is on the insurance company to at least say something.
But are they a party to the case at that point?
Technically, they should have, they could have been, they should have been.
Could have, should have, but were they?
They were not a party to the case, Your Honor, but what I would like the court to think about is how insurance, and in particular liability insurance, works in the Commonwealth, right? We in particular in this Commonwealth take a very broad interpretation of the duty to defend and the different elements that go into the duty to defend. You know, one of which is to retain counsel, or at least to take initial steps to preserve the rights of the insured and the insurer. The insurer is compromising their own rights by not taking action here as well, too. And I understand.
Guy, I'm going to interrupt you. You say in your brief that the Linehans assumed they had fulfilled their obligations by referring the case to safety, correct?
Correct.
At that point in time, were the Linehans represented by counsel?
They weren't represented by their own private attorney, Your Honor. However, what I would say is that to the majority of Americans, contacting their insurance company is the equivalent of obtaining counsel. And if you look in other jurisdictions, right, for example, in California, there's case law out there that says that, you know, for all intents and purposes, it's the same thing because people interpret general liability insurance more or less as litigation insurance. And, you know, why would you go spend money on a lawyer if you just been spending all this money on premiums?
I understand your policy arguments, but let me ask a legal question, which is, insofar as safety, by safety I mean the insurer was not a party to the case, could they have even filed a motion with the court? I don't know that they have. I don't know how they would do that as a non-party.
They may not have filed a motion with the court, Your Honor, but they certainly could have took steps and even instructed my client more clearly as to what he should have done.
Maybe that's so, but if that is so, then perhaps your client theoretically has a cause of action against the insurer. I don't know if they do or they do not, but I'm having difficulty seeing it. Perhaps you can explain to me how safety has an obligation to contact the court. And if you're saying that they do, I'd like some authority for that, a case or a statute or some legal basis for your argument. I'm not saying it's not a good policy argument, but it would be nice to have a case or authority that says so.
Of course, Your Honor. I will be honest, I am unaware of a case that is directly on that point. But what I would ask the court to do is just to put themselves in the position of a non-lawyer in Mr. Linehan's circumstance, you know, being attacked personally and in a limited liability component. So, you know, the question as to whether he could have even answered for the company, right? And
well, I mean, the problem with that though is that he showed himself to be able to know exactly how to contact the court and get more time.
That is correct.
He's got a note. You've got to do something by September 1st, whatever it was. Doesn't it behoove him to check the docket and make sure something's happening? If nothing's happening, Your Honor, I'm still waiting to hear from safety.
Your Honor, that is a great point, but I would have you look at the notice that he actually sent to the court. He notified the court that he was actually going to get representation. And I understand that the court turn that into an order to file an answer within the 20 days. But in essence, Mr. Linehan did exactly what he said he was going to do by going out and notifying the insurance company, which to him was, in most regular people, is the equivalent of obtaining counsel in effect. Now, I understand that, for example, in California, this happens so frequently. They actually have statutes that deal with these types of cases where the insurer and the insured are in this kind of like limbo area. And what I would say,
I don't see that you cite any California cases or statutes in your brief, do you?
I do not, Your Honor. I recently came across this, but I'd be happy to share it with you. And obviously for any questions, I'd be more than happy to file a supplemental brief as well. But what I'm saying is, Your Honor, is put yourself in the mind of the reasonable person. And if you, in Mr. Linehan's situation, if you've contacted your insurer said that they're investigating the claim and taking up at least part of their responsibilities under the duty to defend. If I was a non-lawyer in that position, I wouldn't want to do anything because I wouldn't want to mess up the case.
Does the record in the motion to vacate, did the Linehans, did your clients put in anything, any of those communications that they received from safety telling them that they're going to get the safety will take care of it for them?
Only they only reference their communications with safety in their affidavit, Your Honor. I didn't, in the record below, I did not see any communications that were included by the trial counsel.
So we look at the affidavits of, I think there are a couple affidavits they filed, right?
That is correct, Your Honor. There is an affidavit from Jeffrey Linehan. There's also an affidavit from the broker that ultimately received the broker fee, Mr. Bingle, that brought in Stubblebine. And that affidavit is actually very telling as to the merits of the case, because he explains that he corroborates what Mr. Linehan was saying about the contract, that Mr. Mark Abera was supposed to be an exempt individual under the contract. But that gets to the merits, and under the Berube factors, the trial judge, he didn't even need to hear arguments on the merits. He said it was quite clear that there's a live controversy here. That wasn't a factor that weighed against them. The factor that seemed to weigh against my clients mostly was what he found to be their carelessness. But what I'm trying to say to the court is actually not carelessness. It doesn't meet necessarily the definition of carelessness. He did take action. The judge found he did nothing. No, he did something. The question, was whether or not that was sufficient. And that's
let me ask you, and I appreciate your candor when Justice Neyman asked you about a case that would be on track with the facts here. There are a host of excusable neglect cases. Can you give us a case that's at least analogous to what happened here? Obviously not exact, because you told us one doesn't exist. What's the best analogous case on excusable neglect?
Sure, Your Honor, especially involving reliance on an insurance company action or inaction. The most relevant case that I found was the Scannell case that I cited in my brief. In Scannell, there was actually 2 defaults which weighed against the defendants, but in their major analysis was concerning the second default. And the biggest thing there was that he didn't act promptly. It took 4 years. So yeah, he notified the insurer. He thought the insurer was going to tender the defense, but there was a 4-year lapse of time. At a certain point, the court has to move the case. And that's what they said, that the default in Scannell was not punitive as it appeared to be here, but was a fair and natural resolution to a 4-year-old case that was not being defended or prosecuted in any way, shape, or form. So, and there the court said, as long as the conduct by the defendant wasn't willful or careless, then it could be excusable, but there the 4-year lapse of time was inexplicable. Here, there was no 4-year lapse of time. There's barely any months. It was really a boom, boom, boom scenario from the time of default to entry of default judgment to execution. And then about 3 weeks after that, the insurance company denied. And then my client took immediate action, hired a private attorney. And
Well, let's stop in that timeline, because we know that your client filed an emergency motion for an extension on October 23rd and was granted until November 30th. The plaintiff doesn't move for a default until December 7th, and a default ultimately enters on January the 9th. You agree your client filed nothing when plaintiff moved for a default?
I agree that he filed nothing, but what I would
And you're not suggesting that he didn't receive notice that the plaintiff had moved for a default?
that was suggested in his affidavit, Your Honor. Mr. Linehan testified that he didn't, that he wasn't aware until he received the denial from the insurance company. I'm not entirely sure.
He wasn't aware that the plaintiff moved in court to default until after the insurance company denied coverage in February?
That's what the affidavit said, Your Honor. And Your Honor, in regards to comparable cases, I would also direct the court's attention to, for example, the case of Kylie v. Glynn. Let's see here. That's 2004 Mass App Div 183. And in that case, we have—
Did you cite that case? I don't see that in your brief.
Your Honor, no, that was, again, recent.
All right, so can you give us the site for that?
Yeah, absolutely, Your Honor. It's 2004 Mass Appellate Division 183.
Oh, it's a district court appellate division case?
That is correct.
Okay.
And in that case, Your Honor, some buyers contracted with a builder for the purchase of a lot and building.
You are out of time, but I'm going to let you finish your statement.
Sure, Your Honor. So this is a great case of a real carelessness. Oops, I didn't do anything situation. What happened there is the homeowners sued the builder. The builder did not act. Then, but actually did appear, didn't answer the complaint, but did appear for, I believe it was an attachment hearing. And he prevailed on the attachment hearing, but then never answered the case. And then in his motion to vacate, the only explanation that he provided was oops, I forgot. Now, at the trial level, the initial trial judge—
I think we're going to have to leave it at that. We'll take a look at that case, but thank you very much.
Thank you, Your Honor.
Attorney Eisenberg, when you start to speak, you'll get the clock on the top left corner.
Thank you, Your Honor. David Eisenberg on behalf of the appellee, the Stubblebine Companies. Stubblebine Companies, the court below denied a motion to vacate the default judgment. The Stubblebine Company requests that the court affirm the denial of the motion to vacate the default judgment and that the court award appellate attorney's fees, because this entire appeal lacks merit based on existing law and based on the arguments that were presented below.
Attorney Eisenberg, can I ask a question just by way of background? Specifically, how much time elapsed between the date the default judgment entered and the date of the filing of the motion to vacate?
I believe the default judgment entered the end of January. The motion to vacate the motion to vacate the default judgment, I believe, based on the docket, was around May 1st. It might have been served before then.
So we're talking about 3 months, right?
Correct.
And under the rule, I believe that the court can consider the motion as long as it's filed within a year, correct?
I think that's under 60B6, if I'm correct. They're only proceeding under 60B1.
I thought it was all of 60B, but I will double check that. That's—
Well, I'll defer to Your Honor.
Well, I'll defer to the rule, actually. So in any case, there are any number of cases in which our courts have held that a time lapse of much greater than 90 days has held to be a reasonable time in which to file a motion to vacate a default judgment. And our case law also states that there is a strong preference of deciding cases on the merits. I understand we're under an abuse of discretion standard, but this case does not appear to be one of the most egregious situations which we've come across. So how do you reconcile that case law that I just discussed with you with the judge's determination in this case?
Well, respectfully, I would disagree with Your Honor in terms of where this case falls. First of all, it is an abuse of discretion standard, as Your Honor pointed out. Secondly, I would point out that the Superior Court issued a very well-reasoned decision based on the facts as they were presented. And there are numerous facts in this case which support that the defendants were careless and acted intentionally in not proceeding with this case. And this entire issue of pursuit of insurance was not raised below, certainly to the extent it was raised during the argument today. In addition, the only evidence about insurance in this entire case, the issue of insurance did not even come up until the motion to vacate the default judgment. And it comes up in one line in Mr. Linehan's affidavit. It's on page 87 of the appendix, paragraph 31. After my wife and I were served with a complaint, I notified our insurance company and asked them to defend us. I was told it may take some time to get a response. That is the entire record on communications with the insurance company and what took place. We have no evidence as to when they contacted the insurance company. We have no evidence as to the response of the insurance company. We have no evidence as to whether the Linehans were led to believe that the insurance company would defend and would hire an attorney. None of that is present based on the evidence presented to the court. In addition, Your Honor, prior to filing this suit, as Your Honor knows from the record in the email trail, which these are in the supplemental appendix, pages 51 through 55, is the email exchanges that I had with Mr. Linehan prior to filing suit. I sent him a detailed demand letter where I informed him of the claims that I would be filing and the basis for those claims. Mr. Linehan responded to me. He said he had a large paper trail. He said that if this case proceeded, he would hire an attorney and that the Stubblebine company would be responsible for paying his attorney's fees. I responded and said, send me your paper trail. I'm happy to look at anything you have, or have your attorney call me and we can have a discussion about it. We exchanged numerous emails. Mr. Linehan kept saying that he would hire an attorney and he kept saying he had the paper trail. I asked him no fewer than 3 times over the month in emails a week apart. Please send me your paper trail so that I can evaluate it. Please send me your paper trail so I can evaluate it. Mr. Linehan did not respond with any sort of response to those. Then when I filed suit, I sent him an email that I was filing suit and I sent him a copy of the complaint. He was then served in hand. His wife was served in hand. They knew exactly the claims that we were asserting. Then he sends the letter to the court. He doesn't mention insurance to the court. He simply says he needs more time to hire an attorney. The court, and he asked for 20 days. He knew what he asked for. And as the court below points out, he received the notification from the court that he had until November 30 to respond. He didn't respond. I then requested a default on December 7th. I sent separate envelopes to each of the defendants. And despite what Mr. Guy says, there's no evidence in the record below that they did not receive those. In fact, if the court looks at the hearing transcript from the motion to vacate the default judgment, the defendants admitted at that hearing that they did receive the request for default and did nothing. Then,
and that email, going back to the initial email exchange with Mr. Linehan that you referenced, that was in where he referenced that he would need to get an attorney and you would have to pay costs. That's September of 2018. Do I have the timing of that correct?
Yeah, September of 2018. These are pages 51 through 55 in the supplemental appendix.
Okay, so 3 months prior to the default judgment entering?
Yes.
Okay.
And I said, should you have an attorney, please have your attorney reach out to me. I responded to that directly. And I said, in addition, I said, if I don't receive any other information from you, I will proceed based on the information that I currently have. This is after he threatens that he has an attorney and I'd be paying his attorney's costs. And did I want to go down that road of making him hire an attorney so that the Stubblebine company would have to pay his costs? But back to the chronology, Your Honor. So then I moved for a request for a default judgment. And again, separate envelopes I sent to each of the defendants. There's no dispute that they received those. The court then enters the default judgment. The time to appeal expires. I request an execution. I levy and suspend on their real estate, and I serve them, and the sheriff serves them with the levy and suspension. So all this time they have notice. All this time, Mr. Linehan knows how to get in touch with me. Mr. Linehan knows how to get in touch with the court. And no time does he reach out to me and say, whoa, can you stop? I'm waiting for my insurance. I'm trying to do something here. I never even knew about this insurance till I received his affidavit in connection with the motion to vacate the default judgment. And again,
to go back to what Justice Neyman was asking your brother earlier on, are you aware of any cases that would have allowed safety to come in and file some sort of a pleading at the stage that this case was at?
Not only am I not aware of any case that would allow that, but also I would suggest that to the extent they have a claim, it's not against the Stubblebine company. To the extent that Mr. Guy is correct about the law and based on his brief and the arguments he makes in his brief, again, which were not raised below, his claim is against Safety Insurance Company to the extent there is some duty there. I'm not aware of it, but again, I've read his brief and I know what he's suggesting. But again, I don't know that that allows him to come back and defend this case. And again, in terms of the chronology, the Superior Court details all of her facts are supported by the record. And in fact, with respect to the meritorious defense, I appreciate that while the oral argument was going on the motion to vacate default judgment, she thought there might be a meritorious defense in the beginning when the Linehan's attorney was presenting his case. But as the court knows from footnote 4 in the opinion which is being appealed, the court concludes that defendants lack a meritorious defense. The court actually found that in footnote 4. So, based on the full presentation and her full review of what was presented below. In addition, there is some focus on the entire focus of the appeal brief is on the Berube factors. I would suggest that none of those factors are relevant based on Byrd v. Ross, a Supreme Judicial Court case in 1985, where the court specifically points out when no attorney was involved in the misconduct, that they're not guided by the Berube factors. And that's on page 791 of the Byrd v. Ross opinion. Therefore, the entire argument made in the brief based on Byrd v. Ross are not relevant. And Byrd disposes of this based on the circumstances surrounding the precise omission here, which was either to respond to the complaint or communicate with me or communicate with the court. There was no communication with either me or the court, and they knew all along what we were proceeding. And again, there is evidence, as the court will see from the record below, there are serious issues as to whether this defense is a fraudulent defense based on the contract. And I don't want to get into the merits because the merits aren't relevant here. There's no appeal of the default judgment. It's simply an appeal of the motion to vacate the default judgment. And again, the standard is abuse of discretion.
So can I ask you another question about your fee request? You do cite in your brief to the allegation that the Linehans filed some form of a professional complaint against your client with the Department of Professional Licensure. Is that a proper consideration for us in a fee request in an appellate case?
I'm not sure I understand your question.
In other words, why did you include that in your brief? What is the relevance of the complaint?
The relevance of that, Your Honor, is that Mr. Linehan knew how to express himself and to defend a claim or to pursue a claim if he wanted to. And he could have filed the same thing in response to the complaint here instead of proceeding with a new venue. I also think it suggests that he's doing everything in his power to, attack the Stubblebine company in any way he can. And so he knew what he was doing. that's what I think the relevance is.
Thank you.
In that complaint to the licensure company, it's very detailed in terms of why he thinks the Stubblebine company is not entitled to a fee. And you know, he could have interposed those same defenses here, and he chose not to. Instead, he chose, because he knew at that point, he pursued that after we levied and suspended on his real estate. So he's doing that in response to an effort to actually collect his assets. And I would suggest that his behavior is that he lay in wait until there was actually some, you know, concrete attack on his personal assets, and then he responded.
I mean, the judge finds that that his failure to respond is deliberate and intentional, and not a mistake or oversight. Why would you deliberately or intentionally allow yourself to go into default?
Perhaps he never thought the Stubblebine company would go after his personal assets. Otherwise, but his conduct does suggest that it was deliberate and intentional, because he knew from before the suit was filed what was going to be filed, and he knew that he needed to hire an attorney, and he didn't do it. I can't explain why he acted the way he did. And just to hire an insurance company, going back to this insurance issue, my understanding is this is homeowners insurance. I don't know why homeowners insurance would cover the sale of a business piece of real estate, and whether you owe a broker's fee to somebody in a business sale of real estate by a company. So he's looking to his personal homeowners insurance.
Apparently neither did they.
I'm sorry, what?
They denied coverage, right?
That's my understanding. Therefore, Your Honor, just to sum up, you know, we would ask that the court affirm the judgment below, and that the court award appellate attorney's fees in this case, because the arguments that are being made, some of them weren't even made below, and the ones that are made in the brief lack merit, based on the entire focus, based on the abuse of discretion standard and the opinion issued below.
Do either of the members of the panel have any additional questions? All right, thank you very much. Thank you both. Excellent arguments. This will conclude today's session of the appeals court arguments.